Voters here in California approved a Proposition 22 allowing Uber and Lyft drivers to remain independent contractors.
It meant to protect more than 1 million freelance.
That Uber remains a dependable source of flexible work for California drivers.
The company should not have to provide benefits, including contributions to Medicare and Social Security.
Welcome to Unshut Cases. On today's episode, we're covering Uber and the independent contractor controversy. We have with us an incredible guest out of Irvine, California. Fairchild and Levine, an awesome employment law firm. We have one of the founders of the firm here, Drew Levine. Drew, thank you so much today for joining us on Unshut Cases.
Well, thank you very much for having me here. It's a pleasure.
In just a moment, we're going to hear more from our guest. But for now, let's go to our sponsor.
Mission Control, USS LegalSoft, ready to launch. Yes, copy that. LegalSoft's mission is to find the best legal talent for our client, even if we have to go to the moon to find it.
Welcome back. We're here with Drew Levine discussing the Uber contractor controversy. Yeah, and I'm Dan Taft, the host of Unshut Cases. And again, we're going over an interesting topic today here, Uber and the independent contractor controversy, which, Drew, we had talked a few times about this, and I kind of wanted to just dive right into it. To kind of give an overview, Uber started 14 years ago, has gone on to operate in 70 countries, 10,000 cities with 150 million monthly active users and 6 million active drivers. It really disrupted the taxi cab industry initially. The app has provided nearly 50 billion trips to passengers and has even made its way into our common lexicon, with Uber and Ubering becoming widely used terms. One of the primary discussions we've seen arise over this still very new industry involves the status of Uber drivers and whether or not they should be considered employees or 1099 contractors. So I'll just kind of dive right in there. Drew, can you speak more to that debate just on like a top level? Because you had mentioned this, Uber didn't create this, right? This pre-existed, this sort of employer versus 1099. And if you could just kind of give us an overview of that and what that looks like.
Yeah. So from a bird's eye view, the issue is that when people start companies or when people are operating companies, there's always an incentive and a desire to save on labor costs and to try to figure out how to operate as efficiently as possible. So over time, there was a development in the United States and in the States of the sort of the legal parameters of what constitutes an employment relationship. Mm-hmm. But that concept, the employer-employee relationship, didn't always fit neatly for every type of business relationship where one person was providing labor to another. So, for example, if you were to go out and to hire a plumber to fix your toilet, you're not going to want to necessarily make that person your employee, even if they're doing work for you regularly. Say you own a business complex and you have this plumber doing this work regularly for you. You don't necessarily want to create an employment relationship. So instead, what arose was the independent contractor relationship to provide service to companies or on an as-needed basis. So as these two different types of relationships started becoming more well-defined in the American legal landscape, as you might expect, people tried to avoid some of the regulations and some of the duties that are involved in employing people by trying to classify certain employees as independent contractors. So from that tension, there has over time just been more development, more discussion, more debate about when should people be classified as employees and when should they be classified as independent contractors? And the reason why that's an important question is because the rules around employment relationships are there and they exist and they're intended to protect people from being exploited by companies.
Mm-hmm. Right.
So how do you create a rule that ensures that you're not going to make people who should be employees independent contractors so that you can exploit them? And the Uber case presented us with a really interesting sort of test case to examine examine the outer limits of those doctrines.
Drivers are classified as independent contractors because they set their own hours, while Uber and Lyft take a cut from each fare. New York's rules ensure them a minimum wage, at least in theory.
Yeah, that makes a lot of sense. And, again, over the last 14 years since Uber started, it's had this meteoric rise, right? It really, again, disrupted the taxi cab industry. Would you say legislation had a hard time keeping up with any sort of regulations on the company since its inception? And is some of that just due to how quickly it grew?
Yeah, I think so. I mean, the whole gig economy, the rideshare economy, this new kind of business where you basically would get somebody to respond to you based on some inputs that you were punching into an app on your smartphone. That's all very new, right? This is a new development, a new technology, and usually when technology develops in this way and creates a new way of doing business, legislation's not ready for it. So you have to sometimes work backwards and catch up, which is why some of these questions were first presented to the courts to see if they could figure out a rule. In the aftermath of a lot of the litigation around these questions, like how do we apply the currently existing rules to a company like Uber, the different legislatures have stepped in to try to offer some more concrete guidance as they've consulted with industry experts and others to try to draft rules about how to do this in a way that's fair to everybody.
Yeah, and in terms of, because we keep talking about contractors versus employees, right? That's the distinction that we're drawing. For Uber drivers, like what does that difference look like between if they are a contractor versus what they would look like as employees? For Uber drivers, what are some of the implications of that, drawing that line?
So for the drivers themselves, well, there's implications for both the company and for the drivers. For the drivers themselves, they would not be entitled to certain protections that are afforded to them under labor laws, some other types of laws. For example, in the state of California, we have some anti-discrimination laws, which are a little bit more forceful in protecting employees than they are in protecting non-employees, called the Fair Employment Housing Act. But probably most importantly, the California Labor Code has very little to do with independent contractors. Most of the relationship between the independent contractor and the business is governed by a written contract rather than by statutory laws. So independent contractors do not, for example, get minimum wage protections. They do not get overtime protections. They're not entitled to regular meal and rest breaks. They're not entitled to wage statements and things of that nature that any employee in the state of California would be entitled to.
Okay. Is there a specific state or states that are kind of leading the charge for these drivers being classified as employees versus 1099, or is this sort of going on similarly across the board throughout, well, not just the US, because Uber's international too, but I mean, is there, I guess, a specific locality that seems to be kind of pushing this fight or is making more noise around than someplace else right now? Yeah,
I would say with this, as with most things, California tends to be sort of on the front line of changes in the legal infrastructure governing these types of things. Mm-hmm. For example, a lot of the big litigation cases originated in the state of California. The state of California also passed something called AB 5 or Assembly Bill 5 in 2019, which basically created a statutory test for independent contractors. If they passed this test, and really what it was primarily looking for is whether or not the companies were controlling the work of contractors. If they didn't pass this test, then they would be by default employees. So California tends to lead the way, although I would say New York and New Jersey are not that far behind.
Yeah.
But these things do tend to be litigated in California and fleshed out in California before other states, I would say, learn from our bruises and potentially have a bit of an easier time coming to some consensus on how to do things after they've seen the fallout of our fights here.
Yeah, and you mentioned AB. Forgive me, I don't remember the number that you had behind that AB. But is that the same as or different from? I know there was something called the Private Attorneys General Act, which is a California, I believe, statute. How did that come into play in this case?
Yeah, so the Private Attorney General Act is actually something different.
Okay.
That act, if you've heard of class action lawsuits, I expect.
Yeah. Sure.
So the way the class action lawsuit works is that one person, one plaintiff will sue a company, but they will stand in on behalf of numerous people because you can't have, 100, 200, 300 individual plaintiffs in lawsuit. That's too unwieldy. So the way that we've decided to address sort of more systemic changes is through class action lawsuits. That's the structure. Now, the Private Attorney General Act is similar to a class action lawsuit. What you're actually doing if you're a representative in a PAGA lawsuit, we call it PAGA as the acronym. If you're a representative in a PAGA lawsuit, you're putting the state of California, the Labor Workforce Development Agency in particular, on notice that there are labor law violations going on with a particular company and they're affecting numerous people. The state of California then has 60 days to decide whether or not they want to initiate their own enforcement action and to seek penalties for that. And if they don't, then the individual can sue the company on behalf of the state and recover a portion of the penalties. 75% of it goes to the state of California, 25% goes to the aggrieved employees, the plaintiffs in this case. So the way that PAGA factored into the Uber situation is that essentially Uber was sued in what looked like a class action lawsuit because of this PAGA. So that became a very, very expensive situation and a very expensive problem to have to deal with. And that also drew quite a bit of attention to the issue of potential misclassification. Because if these people should have all been employees, then there were just millions and millions of dollars in violations that Uber had been committing for years and years. So that's why this the Uber case became a subject of attention for a lot in the legal community.
Have you ever thought about putting your firm on a podcast? Our latest episodes and their reels have over 4 million views. If you want to be seen by millions of potential clients, hit the link in our bio right now. Click below to learn more. Yeah, and I think it was 2017, Uber actually agrees to pay out $20 million to the FTC for misleading drivers about their potential earnings. Do you think that was justified in that instance? And if so, what was the case the drivers were making in terms of when they were saying we were misled? What were they kind of claiming there?
This was an FTC enforcement action, so it's a little bit outside the wheelhouse of employment law. It did tangentially involve employment law, which any company that sort of induces people to come work for them under fraudulent pretenses, they're going to be in trouble with the FTC and they're going to get fined by the FTC, right? So with Uber, I think the issue in that situation is that they were mostly inflating the projected earnings for people when they were recruiting drivers. They weren't accounting for all the expenses that the drivers would be individually responsible for. They weren't accounting for like vehicle maintenance, for fuel, for depreciation of their cars. So in a lot of ways, I guess the FTC determined that it was basically a fraudulent inducement to work as an independent contractor for Uber.
Okay. And you mentioned a couple of things there, but in terms of ways that Uber could or potentially did abuse that contractor relationship in terms of pay, I mean, do you see that liability being, because again, some things are a bit implied, right? Like if you know that you're going to pay for gas, there's things that come with car expense. How much of that would you say was on Uber's side versus the driver's side in terms of that contractor relationship?
Well, my view is that generally speaking, companies have way more bargaining power than individuals do. And so if you're going to hire so many people as on an independent contractor basis and essentially strip them of their ability to like collectivize, they can't become a union, for example, and they're not going to have the protections of the labor law in order to ensure that they have some measure recourse if they're abused, aside from just suing under the contract. So in my view of things, I think that...
So over time, the money that we take as Uber and Lyft drivers has gradually been going down, and it's at its worst right now. I quite remember when we started driving for Uber and Lyft, per our contract, they were supposed to only take 25%, and then we get 75% of the ride. But that's not the case anymore. They take, I would say, at least 60% of our fare right now. And that is just not good for us drivers. And you have to put in more hours now. There's no transparency, because we used to see how much you as a passenger got charged for the ride, but not anymore.
There was a lot of potential for abuse. I do think that Uber has worked to strike the right balance with its drivers since a lot of this was going down, so that people were more comfortable. And at the end of the day, I think that in the Uber situation, drivers tended to want to be contractors rather than employees, just because it gave them a lot more ability to work on their own time and work sort of in their own way, where employees would be subject to a lot more control.
Yeah. In terms of the classification, employer versus independent contractor, how does that impact insurance claims that are made against drivers?
Yeah, so it limits it, right? So if an independent contractor is, I mean, the doctrines are functionally that if an independent contractor is in the process of performing work for the company, then the company can potentially be held liable. So if like a passenger is in the vehicle, but say the Uber driver is in between rides, for example, and it gets into a collision, Uber would not be on the hook because the driver was not active. Whereas if they were, even though they're going out and about in the world and trying to find rides, whereas if they were an employee, the employee would or the company would basically be liable for any of the harms the employee is causing during the entirety of the shift. I think that's probably one of the biggest ways. So there is some protection for consumers and for accident victims under this independent contractor model, but far and away, if there were employees, Uber would be significantly more on the hook. And I would say that this is one of the problems of the relationship, because I do think that when Uber drivers are out and about trying to find rides, they're really doing that for the benefit of Uber in addition to themselves. So that is a shortfall, in my opinion.
Yeah, that's a really good point. And again, Uber, before we had Uber, obviously we had taxis. The taxi cab industry is this enormous, legacy industry. If you compare them, how does Uber and other, rideshare apps compare to how the taxi cab industry operates? What are some of kind of the core differences between structurally how they're set up?
I think that the main difference is that the taxi industry is just heavily regulated. There's regulations all the way up and down that. So the individual taxi drivers need to, have licenses to be taxi drivers. They need their taxi medallions or permits. They are almost always classified as employees, or at least they operate under a regulated system.
Yeah.
I think one of the biggest ways that you see differences is that taxi fares are usually set by statutes or regulations. So the city, I think cities that set those fares, and all taxi drivers have to honor them. Whereas with a company like Uber, they have algorithms to adjust the rates based on what they think the particular demand of the time that the ride is requested might be. I would say it's not typically as good for consumers. My experience is that, especially now, taxis are very often a little bit cheaper, and I think it's a little bit better for the taxi drivers in the long run. So I prefer to take taxis when I can instead of ride shares.
Yeah, interesting. I've also kind of come up against that a few times, especially when I'm like going in and out of the airport, kind of faced with that like interesting choice that didn't, again, 15, 20 years ago, like didn't exist. So I just want to hop really quickly to like food delivery services, right? Because I mean, Uber has Uber Eats, but then you have like Postmates and DoorDash and all these other ones. Those are also sort of in their own meteoric rise moment, or actually happened for the last few years. Certainly since like the pandemic and the lockdown, it's like they just blew up. Is there similar legislation coming down the pike for that industry? What does that look like?
I don't know if there's any legislation that's targeted to address that specifically. They're also part of the gig economy. So a lot of the work that had been done in order to figure out the Uber situation applies to those as well.
Yeah.
A very similar model of using an app to request services, similar model of having people be independent contractors, having them be able to sort of choose their own hours of work. And so I don't see any substantial, and maybe that's just my ignorance, but I don't see a substantial difference between the problems facing those two particular industries. It's very similar to me.
Yeah, there is certainly a lot of crossover. In terms of like the foreseeable future with Uber drivers and this employment status controversy, what do you see happening? Do you predict that it's going to kind of stay the course where we are now, or do you see any more like sort of seismic shifts or kind of push back against any of this stuff coming up in the next even year or two?
I think California has basically figured out what they want to do with independent contractors generally, and with the carve-outs that are written in for participants in the gig economy. I don't think it's going to change substantially, because I think Uber drivers are largely satisfied. The ones that I've talked to when I've taken rides from them, they seem okay with the setup. A lot of the complaints that they used to have about unfairness have been addressed in ways that make them okay. I mean, they're never going to be they're never going to be millionaires from driving Uber cars, but they think it's worth their time to do it. So, at the end of the day, law is about finding solutions that work for people and trying to create rules that you can apply consistently that makes our societal interactions fair. So as long as everyone's satisfied, I don't see any reason to make major changes.
Yeah, no, that makes sense. We talked a lot about kind of like the gig economy as a whole. It's certainly become more of a staple throughout the entire US, probably, in many other countries as well. Do you think wider legislation is needed to regulate these contractor-focused industries as a whole? Or again, to your last point, I mean, right now it seems like there is kind of, a sense of satisfaction among a lot of them. Are we kind of in a better place now than maybe we were even a few years ago when a lot of this was kind of bubbling up?
Yeah, I think we're in a better place. I think that the struggle is going to be, how do you ensure that people aren't exploited? And that should be sort of the question that guides any efforts to address this situation. How do you make sure that people are not, because we have a long, long history, and probably as long as, the human race has existed of people who own exploiting people who work.
Yep.
Right. So I'm troubled by the fact that gig workers can't unionize, can't, come together and collectively bargain in the way that employees can. So maybe there's something that needs to be done on that front to create like sort of quasi unions for gig economy workers or something like that. But at the end of the day, it's still a little unclear to me what would drive further legislation on this topic, so long as people are satisfied. The litigation has cooled quite a bit in California. People are still arbitrating disputes with Uber, which is sort of like private court. But I don't know if there's any significant work on the horizon to further clarify. And I don't see some of the more conservative states having the appetite to protect workers' rights in the way that California does. They tend to be a little bit more supply side friendly, you might say. So should there be more protections? I would say yes in a vacuum. Hard to imagine how that's going to happen.
Yeah. Well, Drew, again, thank you so much today for going through this with us and kind of, just overviewing it. It was a really interesting topic to discuss. Again, for our audience, Fairchild and Levine, incredible employment law firm out of Irvine, California. Drew, please tell our audience where they can find you.
Yeah, you can give us a call, 949-409-9005. That's our office phone number. But we're located in Corporate Park in Irvine, and we we serve all of California. We represent employees all throughout California, from the very tip top all the way down to near the border. So the rules are the same for labor all the way through. So if you need help, give us a call.
Awesome. Well, again, Drew, thanks so much for being on Unshut Cases, and we'd love to have you back soon. And thank you.
You're very welcome.